So when we continue from where we left off, this means that the minister is in charge of establishing the small claims courts, and that should stress on the fact that the person who will be appointed, as I have said, that is advocate or an attorney must have been employed as such or practiced as such for an uninterrupted period of at least 5 years, practicing as an advocate or an attorney, or occupied the post of magistrate, or for that period was involved in the tuition of law and also practiced as an advocate attorney for such period as, in the opinion of the minister, makes him suitable for appointment. Right? That means if you say, I've practiced enough, it's not 5 years, but if the minister is satisfied or is happy that you can be a commissioner, then the minister can appoint you, right? If he feels that you possess such an experience, as in the opinion of the minister, renders him suitable for that appointment as commissioner, then you can be appointed, right? And then also, it's very important to know that this is done at the pleasure of the minister. Commissioner shall hold office during the minister's pleasure. That's a very controversial one. And also a commissioner may resign by notice in writing to the minister. So if you want to vacate the office, you first notify the minister in writing to say, hey, I think in 3 months' time, I don't want to be a commissioner. Then you can do that. The minister may at any time, that's the difference. Minister may at any time withdraw the appointment of a commissioner if in his opinion there is a sufficient reason for doing so. So the minister won't give you notice; he will just withdraw you. Said, Mr. So and so, Miss So and so, you are no longer suitable to be a commissioner. Please leave. That is bad. And also, a person appointed under these above sections shall, before commencing with his functions as a commissioner, take an oath or make an affirmation. In case it depends whether you believe in God or you believe in other God, then you take an affirmation or you take an oath, right? And you will say, I, Senzo Makatini, do hereby swear or do hereby solemnly and sincerely affirm and declare that whenever I may be called upon to perform the functions of a commissioner in any court, I will administer justice to all persons alike without fear or favor or prejudice, and as the circumstances of a particular case may require, in accordance with the law and custom of the Republic of South Africa. So help me God. And then you raise your right hand, and say, so help me God. Right? Such an oath or affirmation shall be taken or made in an open court before the most senior available magistrate. So it must be taken before the most senior available magistrate, right, of the district in which the seat of the court concerned is situated, and he shall at the foot thereof make a note to the effect that it was taken or made before him, and of the date on which it was so taken or made, and append. That is very important. You need to append your signature as the senior magistrate, right? So you have to sign that oath was taken in front of you. Also, the procedure that has to be followed if the commissioner was appointed at the pleasure of the minister. When by reason of absence or incapacity a commissioner is unable to complete the hearing of an action, that hearing shall be commenced de novo before another commissioner, right? And then officers of the court, that is section 11, the magistrate of the district in which the seat of the court is situated shall appoint so many clerks and so many assistant clerks of the court, interpreters and legal assistants for the court as may be necessary for the performance of the prescribed functions. So it will be the magistrate, right, who is authorized thereto. The messenger of the court appointed under the Magistrate Court Act 9 of 1944, that is Act 32 of 1944, for the magistrate of the district shall act as a messenger of the court for a court in that part of the said district falling within the area of jurisdiction of the court. The state, a clerk of the court, an assistant, or an assistant clerk of the court or a legal assistant shall not be liable for any damage or loss resulting from assistance given in good faith by the clerk of the court, assistant clerk of the court, or a legal assistant to any party or prospective party to an action before court or to the enforcement or of judgment of order in terms of section 41 in the form of legal advice or the compilation of preparations of a summons statement or other document. So you cannot, because these are just assistants and they are not professional, so they cannot be blamed for any damage that has been caused or that has been caused by whatever force, right? And the area of jurisdiction of the court shall be the area or district for which it was established. And now let's come to transfer of actions. Let's say now we want to transfer the actions for whatever reason. An action may with the consent of all parties or upon the application of one of the parties who satisfy the court that the hearing of action in that court may result in undue expense or inconvenience to him, be transferred by the court to any other court, and in such case the latter court shall, notwithstanding anything to the contrary in this act contained, have jurisdiction to hear that action. So by consent it can be transferred, right? Jurisdiction in respect of a person, any person who resides, carries business, or is employed within the area of jurisdiction of such court shall have, the court then shall have jurisdiction because you stay there or you conduct business, or any person in respect of any proceeding incidental to any action. If you find yourself enjoined to an action, then that court will have jurisdiction, right? Because it's incidental jurisdiction, right? Also, we talk of incidental jurisdiction, that in an action in which the sum claim does not exceed the jurisdiction of court and is the balance of an account, the court may require into and hear evidence upon the whole account, even though that account relates to items and transactions exceeding the jurisdiction of the court. So that's now incidental jurisdiction. Where the amount claimed or other relief sought does not exceed the jurisdiction of the court shall not be deprived of that jurisdiction merely because it is necessary for the court in order to arrive at a decision to give a finding upon a matter beyond its jurisdiction. And then remember subsection 18, that is now, who talks about the abandonment of the claim. If you feel that the claim, because the small claims court jurisdiction is only 20,000 rand and somebody owes you 22,000 rand, so that means it is beyond the jurisdiction. But you can follow the provisions of section 18 and abandon part of the claim in order to bring a claim or a counterclaim within the jurisdiction of that court. So you can, in your summons or statement or of defense or any time thereof, explicitly say, I abandon part of the claim or counterclaim, and then the court will have jurisdiction. Okay, let's talk now of the deduction of admitted debt. Now you see that somebody owes you 80,000 rand, and the amount that fits the jurisdiction of the court is 20,000. And now what you do what is called deduction of admitted debt. So in order to bring a claim or counterclaim within the jurisdiction of a court, a party may, in his summons or statement of defense or any time thereafter, deduct from his claim or counterclaim, whether liquidated or unliquidated, any amount admitted by him to be due by him to the other party concerned. So if you admit, no, I know that I owe this guy 100,000 rand, but if he says 120, I am not prepared to pay 120. So that 100,000 will be deducted because it's admitted, and then there will only be a claim for 20,000 right? So let us then again end it here.